September 10, 2012. This is Justice Done Dirt Cheap. Right across the street is a Fredericton police cruiser, which is a common sight in the city of Fredericton. We are at the Justice building. We just had a hearing. How are you doing today, ladies?
Doing well, thank you.
All right.
And would you like to introduce yourself?
I'm Sally Brooks.
Jen Womble.
And you were at court today,
Yes.
witnessing, observing a hearing. And that hearing is regarding the city of Fredericton, who filed a motion where they want costs to be paid preemptively before an appeal could be heard. What are your thoughts on this?
My thoughts are, since the appeal is actually about the award of costs, the costs in question, why would they want to seek an order for those costs or part of those costs to be paid before the appeal court has even heard it? And why would they ask the very judge who ordered the costs against the plaintiff, Andre Murray, to make that decision? And she is also fully aware that Mr. Murray has tried to file a recusal motion, which she dodged by simply giving it back and telling the clerk to reject it, because Mr. Murray wrote on the date of his next hearing. And now he has to refile it, blah blah blah, but she knows there's a conflict of interest. She's behaved very badly towards him in previous hearings, and we all went in today knowing she will not be ruling fairly or justly, but how is she going to do it this time? What is her excuse going to be this time? Is she just going to regurgitate all the lines that the city lawyers fed her, which is exactly what I think is going to happen.
Yes, and what's amazing is that the city is claiming contradictory to state that the plaintiff, Mr. Murray, does not have sufficient funds to eventually pay costs if the city is successful on appeal, yet they, on the other hand, they're saying that Mr. Murray has plenty of funds to actually pursue actions. So either Mr. Murray has the funds or he doesn't. And they can't say both and just say, oh, just rule in our favor because he may have it and may not. Just rule anyway.
And they can only actually ask for the security of the costs if they believe he does not have sufficient funds. But I don't remember ever hearing at any point that they've actually outright asked him if he's got the financial means. And they've also complained about having to file motions and papers and how much it's costing them. Well, why did they bother filing this one? All they had to do was wait for the appeal.
Then if it would have been one set of costs and the appropriate judging body, which is the Court of Appeal of New Brunswick, whose job is to review lower court decisions, would have been exercised, and they would have had one set of costs going into that. But instead, they filed this in-between motion,
yes,
where they incurred all this extra costs. And I think it was pointed out quite clear at the hearing, they filed affidavits that take up, it's about as thick as a phone book, and then their brief is about a fifth of that. It's a huge amount of paperwork and effort going into this motion, which seems to be simply a legal strategy to try to keep the Court of Appeal from actually considering the merits of the appeal. Because I think anyone actually reading Justice Judy Clendening's decision, which is being appealed, would wonder what she was thinking when she wrote that. I mean, it's obvious that there's quotes where she quotes the original statement of claim and the amended statement of claim, stating, well, look, this doesn't make any sense, but anyone reading it, it's obvious it does make sense. There's actually recognizable tort, the parties are named, the incidents are named. You're wondering what were they thinking, or what was she thinking when it came to that decision?
Well, I think the only agenda in that court is squash any action that actually exposes the wrongdoing within the establishment, and this is about wrongdoing by the city and the police against the plaintiff. And judges, I'm just seeing every single time I go into one of those courts, judges protecting the wrongdoers within the establishment itself. There is nothing unbiased about these judges. They are totally wrong and purposely and willfully making rulings and orders against plaintiffs that hide the hypocrisy in the government in New Brunswick and the city.
And Jen, yes, the court addressed you directly today.
Oh yes.
What happened there?
I was whispering in court. Last time I was making faces. This time I was whispering.
The same judge.
Same judge.
This time you're whispering, and that was a problem.
Yes, it was a big problem. Amazing,
isn't it?
Yeah.
And what's really quite alarming is that at this hearing today, two people were present. Those two people are Trina Rogers and Neil Rogers, who have filed charges. Neil Rogers filed an assault charge against me, and both Neil and Trina Rogers claim to be in fear of me, and they claim that because they're in fear of me, they had the police impose an undertaking on me, which I've been subject to for months. And the trial is not set till middle of next year, which puts me under an undertaking for almost a year, because these people, yet people who claim to be in fear of me, are appearing at hearings, sitting in the audience as spectators.
And the hypocrisy of the judge, when you asked if she would order them out of the courtroom.
I demanded it. I said, I demand.
She said she has no powers to order such a thing. But we know she absolutely does have, and even orders aside and jurisdiction aside. All she had to do was, please, Mr. and Mrs. Rogers, would you mind stepping outside unless you're needed for anything? Bear in mind that the undertaking says Mr. Murray is not to be in their vicinity or have any contact with them. So what is a judge doing, allowing them to sit in the same room with someone who has signed an undertaking that he will not be anywhere near them? That's the ultimate hypocrisy, yet again, from a Fredericton judge.
And I'm asking to not be anywhere near them, and the judge is saying, well, too bad, they can come right up here and cozy right up to you.
Yep.
Even though if I was to cozy up to them, I'd be in breach of an undertaking, which is a criminal charge of 6 months to 2 years.
Yes.
How ridiculous is that? It's these types of maneuvers and statements and actions in court that bring the administration of justice into disrepute.
And what made me laugh about her refusing to ask them to leave is not too long ago, we were in a hearing in provincial court where you actually asked Judge Mary Jane Richards why she made a particular decision, and she said, why? Because it's my court.
Yep.
That's right,
and I can do whatever I want.
And I can do whatever I want.
And not long ago as well,
She said she was going to take you out of it.
She was going to order me out of the court just for having stood up and said, I have a power of attorney to speak for Mr. Murray, who's not very well. She told me to shut up and sit down, or she would have me ordered out of the court.
And physically removed.
Physically removed by the sheriff.
And ironically, okay, well...
Jennings threatened to have me removed as well when I was making a face.
So how is it that on one hand, and I can say yes, I was physically dragged out of the courtroom one day by Justice Mary Jane Richards, who didn't want to answer a simple question of, is there a notice of prosecution before you? If there's not a notice of prosecution, the New Brunswick Provincial Procedures Act requires that this matter be thrown out, and I no longer have to address or respond to this bylaw. Yet she refused to answer, and instead had 2 sheriffs physically drag me out by my heels out of the courtroom. Yet today we hear a different story.
Yes. And Justice Mary Jane Richards had to have you removed from the courtroom because she had a courtroom full of public people listening to a question that would have exposed the fact that she abused the process herself by not even having the right document in front of her to initiate a prosecution.
And basic judicial notice requires her to even know what the correct procedure is, and for her to go ahead with the incorrect procedure and the incorrect documents, she's responsible for that.
Yep. But I can only say again that every single judge we have is handpicked and cherry-picked about how good they're going to be at shutting down the truth, preventing justice, and basically covering for a very corrupt government in New Brunswick. And I no longer take it personally. I just watch them and think, my goodness me, we're seeing it in action again. And they're so blatantly, brazenly hypocritical and actually breaking the law themselves.
And we gotta wonder, we got a little squirrel behind you there, right? Lots of wildlife here at the courthouse. You'd almost call it a zoo. But all right, so one last thought I want to address is the appropriateness of a judge, as in Justice Judy Clendenning, considering a matter where it's brought before her that I want her to recuse herself, because I believe I will not have a fair hearing before her. She has made so many decisions against me that do not make any sense whatsoever, and altogether the massive decisions show there's a trend where I will not have a fair decision before her. Not only that, she can't even keep her composure in the hallways or on the streets to even act civil towards me, as in just other judges give a little head nod or an acknowledgement, they're polite. There's no need for them to say anything to you other than just acknowledge you there and keep moving. But with her, it's basically just come short of her spitting on the sidewalk in front of me. She has so much disdain for me, and I don't understand why. She's got a problem with me, and I'd like to have an unbiased judge, at least the appearance of unbiasedness I deserve.
Do you have a thought on that?
Yeah, well, I do, about the case itself. What I saw, the lawyer for the city was saying, we know he has money because he's able to file all these papers, do all these documents, so there's some money somewhere. But she also admitted that she herself did a physical check on property in New Brunswick to ensure you did not own property, so that they would know for sure that you have a sum of money somewhere that they can get their hands on.
Yes.
That's what I got out of today.
And also...
And that's what they basically said to the judge. He has money, we want it.
He has money, we want it, but also
he doesn't have it in property, so we want you to make sure we get our money.
They also said the difference between the two. Now, if the courts are supposed to favor people with property, that would show an unequal treatment to litigants, because we're supposed to be all equal before the law, and whether one actually owns property in New Brunswick or not should be irrelevant. If one has merit and they're moving through the court systems and can actually follow procedure, pay for the appropriate filing fees, then one's land holdings should be irrelevant.
Well,
they shouldn't be searching for
that entire clause is, to me, is a charter violation. Section 15. Every single person is entitled to equality in and before the law, to equal benefit and protection of the law. And if the city of Fredericton is going to send its lawyer to say, we're going to stop this man's appeal, and we're going to make sure we're going to stop it because of money, that's not equality in and before the law. That's not equal. That's saying we're going to stop your access to justice.
What's interesting as well is that they argued, as in Leanne Murray argued, that the moving party, the city of Fredericton, does not have to prove that I would be unsuccessful at trial. All they have to show is, all they have to do is assert that I won't be, yet the reciprocal is not true for me, as in I assert that I will be successful, yet they want to dismiss the fact that I'm asserting I will be successful, and they claim that has no merit because should have no weight. So why one and not the other? How could that's not equal?
Well, how can a city lawyer make the decision for the Court of Appeal?
And how could a judge who's judging her own decision, which is impugned and under review, give an unbiased, objective decision where she has no place to do so? She's not a three-court judge of appeal. She's not trained to review appeals in that fashion. And how can she be objective? Either she's going to be found, either it's going to be obvious she didn't rule against herself, or there's some reason for her to rule against herself for some other reason. How could we believe that she's objectively going to provide an unbiased decision? I ask you that.
We can't.
The only thing I'm confused is why she didn't do her usual, I'll be back in 5 minutes with the already typed results. Why is she making us wait until 1 o'clock? That's unusual for her.
I think that's because we blogged it, and she must have seen the blog saying she had obviously pre-prepared her decision.
Yes.
So now she's trying to make it look as though she's going away and thinking long and hard. I want to come back to one point you made about why she won't recuse herself. I think it is because she has created such an almighty track of wrong and horrendous decisions that I don't think there's another judge that wants to take it on.
It's a nuclear bomb site.
If the next judge makes a different decision to what her track record is proving to be of rotten, mean, evil, corrupt decisions, Mr. Murray will have all his proof. So she can't afford to hand it over to another judge, and she can't afford it to go to appeal. So she's trying everything she can, and I have no doubt she sat and had a glass of wine with the city solicitor to discuss how they're going to do it. This is the result.
The other thing that was interesting as well, just on a final note, is that they actually tried to slide in an affidavit by Neil Rogers, which would have been totally against procedure, and if I had not stood up and said, wait a second, I was never served that document, I'm not aware of that document, the rules of court demand that I be served, I want that rejected immediately. And instead of just admitting that, okay, if it wasn't served on you, it should not be part of the record, the judge instead said, well, how about you read it over, and I'll just take a recess here, and you can just consider it. Well, what's there to consider? If it's not been followed, if due process is not followed in proper procedure, then I'm entitled to just have that affidavit, which was going to be used against me, to be dismissed. And they decided, as in, they withdrew that affidavit.
And I think they had to withdraw it because they've been so tight and hard with the rules against self-represented parties that they now can't be seen to be so blatantly breaking the rules. But what on earth did a judge do, even accepting it and reading it, when she knew there was no record of it having been served on the trial record?
She shouldn't have had it.
No.
Amazing, isn't it?
Or is she just blatantly incompetent?
What's interesting
Ding,
too
ding,
is
ding, ding.
on a final note, it should be stated that the Canadian Judicial Council has stated that when considering the submissions of self-represented parties, that the judge should give special leeway and take judicial notice whenever a self-represented party files a submission, because they're not professionally trained. They're doing their best to overcome some very convoluted rules of court. They're not easy to follow. I mean, an intelligent person can read them, you know, make it happen, but it's not a step-by-step fill-in-the-blanks easy process.
The city lawyer brought with her a book of law that was the size of 2 telephone books that she kept looking up throughout the hearing. None of us have that.
Nope.
We don't even know how to look it up in those books. So it's not an even playing field.
Yes, and just as a final note, the Canadian Judicial Council has stated in their written they've written documents, and I'll have to put a link to this video where anyone can go read the Canadian Judicial Council. I forget what it's called. It's basically an article about self-represented parties and how they're supposed to have a fair shake in the court system, and why the judges should give them extra leeway, not give them legal advice, not direct them on what to do, but at the same time give them special allowances, and especially pay judicial notice to anything that should be stated on behalf of a self-represented litigant. All right, thank you for that, guys.
Pleasure.
This is Justice Done Dirt Cheap at the so-called Justice Building, September 10, 2012. Thank you for listening.